Madam, I would like to clarify some of the issue raised by Mr. Satpathy about why ordinance was there. We could bring the bill, but I would like to make it clear that the Companies Act 2013 and thereafter the IBC, Insolvent Bankruptcy Code, was enacted in 2016. So in that code, the creation of the NCLT, National Company Law Tribunal, whereby since the large number of NPAs was there, so every type of matter, even the small matter relating to changing of the name of the company, changing of the financial year, every matter was required to go before the NCLT. So it created huge number of cases and areas with the NCLT, around 40,000 cases. So if we count it, around this more than 50% cases related to this cases relating to lapses of the technical nature or of procedural nature. So question is whether those cases are required to go before the special courts, those cases are required to go before the NCLT. So the serious cases of the fraud are not being disposed of promptly. Therefore, it was decided to constitute a committee under the chairmanship of the secretary. Committee was constituted, certain recommendations were given for recategorization of the offences, where those offences which are compoundable, those offences are not required to be dealt with by these special courts. Those offences are not required to be those cases are not required to be dealt with by the NCLT. Therefore, with a view to declog. And the urgency is, madam, because if we go on keep it, then it was the very purpose of enacting the IBC code was frustrating, because the large number of NPAs were there and the timeline was also fixed under the IBC that within the certain period those cases were required to be disposed of. Those cases were not, the court was not in position to dispose of those cases because the large number of pendency of the cases which relate to lapses like this technical nature or procedural nature. Therefore, it was decided to all the compoundable offences are required to be dealt with by the in-house procedure mechanism in the ministry itself, and those cases are not required to be dealt by them. So with that view to declog this special courts as well as NCLT, so this ordinance was immediately enacted, and it basically, so we will also decide that no doubt this came into force with effect from the date when it was issued, but we will certainly also take into consideration that those cases pending prior to coming into force of the ordinance. We will also decide how those cases can be withdrawn and those cases can be dealt by the in-house mechanism. So once we do it, then the burden on the NCLT and these special courts will be very, very less, and they shall be in position to decide the cases as per the mandate given under the IBC. The IBC has been passed by the Parliament, and the mandate has been given that within the stipulated period those cases are required to be decided. And apart from this, I would also like to make it clear that large number of companies were registered, and we, under the able leadership and visionary Prime Minister, the प्रधानमंत्री जी ने डिसाइड किया कि ऐसी कंपनीज जो कि बहुत लंबे समय से जो बिजनेस नहीं करती हैं, मनी लॉन्ड्रिंग करती हैं, ड्रग फंडिंग करती हैं, टेरर फंडिंग करती है, इन कंपनीज को, जो सेल कंपनी जिसको हम कह सकते हैं, कुछ कंपनी नॉन कंप्लायंट कंपनी जो रिक्वायरमेंट है लॉ का 248 का, वो रिक्वायरमेंट फुलफिल नहीं करती हैं, टू टेक द एक्शन अगेंस्ट दोज कंपनीज विद द व्यू दैट द सेक्शन 10A, जो नया सेक्शन जो इसमें बिल में जो है सेक्शन 10A लेके आए हैं, तो उसके लिए उन कंपनीज को चेक करने के लिए अगर उन कंपनीज के अगर वो कमेंसमेंट ऑफ द बिजनेस अपना डिक्लेयर नहीं करती हैं, अगर कमेंसमेंट ऑफ बिजनेस उन्होंने डिक्लेयर नहीं किया तो ये माना जाएगा कि ये बिजनेस करने के लिए कंपनी बनी नहीं है, उसके लिए पेड ऑफ शेयर कैपिटल उनको पे करना पड़ेगा। तो ये सारा देखने के लिए सेक्शन 10A इंट्रोड्यूस किया, ये भी बहुत जरूरी था, जल्दी था, इसलिए इमीडिएटली एक्शन लिया गया। एंड अपार्ट फ्रॉम दिस, section 12 was also, new section was also added to ensure that they are required to maintain the registered office. So not only the registered office, they are required to maintain it. There must be a physical office should also be there. अर्लियर क्या होता था, लार्ज नंबर ऑफ कंपनीज जो थी यूपीए के रिजाइम में, ऐसी फर्जी कंपनियां जो बनी थी, उन कंपनीज को उन्होंने किसी तरह के उन्होंने सह दिया और उन्होंने उनके खिलाफ में किसी तरह का एक्शन नहीं लिया, और मनी लॉन्ड्रिंग का काम करती थी वो कंपनीज, तो उनके खिलाफ में हमने एक्शन लेने के लिए करीब 3,25,000 कंपनीज को हमने स्टॉक अप किया और उनके बैंक अकाउंट सीज किए, और बैंक अकाउंट सीज करने के बाद में उनके प्रॉपर्टीज के लिए। और इस तरह की कंपनी जो ऐसी कुछ कंपनी ऐसी भी थी जो ड्यूरिंग डीमोनेटाइजेशन उन्होंने करीब, एक कंपनी ऐसी भी थी जिसने 3,700 करोड़ डिपॉजिट कराया और विड्रॉ किया। ऐसी भी कंपनी थी जिन्होंने 2,300 करोड़ रुपए डिपॉजिट किया और विड्रॉ कराया। तो इन करीब 68 कंपनीज के खिलाफ जो है इस तरह की कंपनीज, उनके खिलाफ में एक्शन भी एनफोर्समेंट एजेंसीज के द्वारा, अलग अलग एजेंसीज के द्वारा वो भी इनिशिएट हुआ है। तो इन सारों को देख करके ऑर्डिनेंस जो लाना इसलिए जरूरी था, क्योंकि इनको डीक्लॉग अगर नहीं करते तो और भी केसेस बढ़ जाते। तो उससे जो पर्पज जो होता आईबीसी का, इंसॉल्वेंट बैंक्रप्सी कोड का, के जो टाइमलाइन दिए हुए हैं उस टाइमलाइन में नहीं हो पाते, इसलिए ऑर्डिनेंस लाना पड़ा। इन शब्दों के साथ में मैं रिक्वेस्ट करूंगा कि जो बिल जो हैं पास किया जावे। मैडम, मिस्टर Bharatiya Mehtab raised some important issues regarding definition of the shell companies. So far as the word shell is concerned, it is not defined in the Companies Act.
That is, he exactly said.
This, so that's why I have used not only the shell companies, but I have used the word non-compliant companies. So the company which is not doing its business and it is doing the money laundering business, doing the drug funding, terror funding and illegal activities.
Yes.
And as such there is no business at all. Those companies are termed as shell companies in local parlance, but as this word as such has not been defined. But as far as non-compliant companies are concerned, under section 248 of the Companies Act, if the company failed to file the return and financial statement in a consecutive 2 years, then that company we will treat that they are not having any business. And those company we can issue a notice and we can take an action against that company, that since you are not doing any business, it shows that company can be struck off. So that with that purpose, we have again in this bill, we have introduced section 10A and section 12, because Mr. Mehtab has raised the issue that how you can curtail such type of companies by bringing this. So it is very clear earlier what happens, large number of companies were having without any office, physical office. There was no question of maintenance of any office. So that's why we have introduced section 10A in this bill, by way of this bill, and along with this, the section 12 is also there. So if we read both the sections, it makes it clear that company is required to maintain its registered office. Not only the registered office, they are required to maintain it. There must be a physical office. So that's why the physical office is a mandatory condition precedent. And apart from this, the commencement of business. If the business, they have failed to commence the business, then we can say that the company is, in fact, then it can be struck off. So we have provided more provisions, and thereby the consequential amendment has also been introduced under section 248 in this bill. So we have also taken into consideration section 10A and section 12. So this is with respect to the shell companies. And apart from this, the recommendations, large number of recommendations are there by the committee constituted under the chairmanship of the secretary. So no doubt, number of recommendations are there. The government has taken into consideration all the recommendations, and the recommendations which are required to be incorporated and included in the ordinance, they have been taken. And after the ordinance, the government again reconsidered those recommendations and found it some more provisions were, because some provisions were compatible and earlier, so that's why some more provisions were introduced. And for strengthening the ROC, because it is not, we are basically giving the power to the regional director, not the ROC. So it is not an issue here involved in this bill. But so far as this RD is concerned, whenever, if the workload is more, we will increase the post. And so far as ROC is concerned, if the workload is more, it depends upon the workload. So whenever the workload is, then the government shall definitely take into consideration all these things. So far the punishment part is concerned, because some of the offenses were of compoundable nature and some serious offenses, because the government would also like to show it that with respect to serious offense there can't be any sort of compromise. So with respect to serious offenses, they are required to be dealt with as such. There is no amendment with respect to the serious offenses, cases of the serious fraud, and those are required to be dealt with as such, and there is no amendment. Only with respect to the offenses which only related to lapses of nature of the, it may be a procedure, It may be of technical, and for that purpose, even the punishment was provided, penalty was provided. So that's why such type of offences were recategorized, and those were converted into civil offences. And once these are treated as a civil offences, then they are not required to be remitted to the special courts. Then they will go before the competent authorities. In-house procedure mechanism is provided. And so far as I have already informed the August House that so far as the cases pending before the special courts, pending before the NCLT, and after coming into force of this amendment, because we can't make it applicable with retrospective effect, but certainly government shall take into consideration for withdrawing those cases and taking out from the NCLT and this special courts and dealing with by the competent authorities. So all this, the question.
Independent director's salary.
So far the independent director.
So why you put a cap?
Just a minute, because
why you put a cap? The company is paying to the independent.
Since you have raised now, I am responding it. So far the director's part is concerned, we have also provided the provision under section 64. And this is also one of the grounds, because the directorship number has already been provided under section 165. If it exceeds, individual director exceeds the number of the company in the directorship, then he can also be disqualified. The provision is also there. So with this, I request the...
My question was relating to the cap in the salary of independent directors.
That is
the company is to pay the salary. But so why through this bill you put a cap? It is left to the company to decide how much they are going to pay. But why should the government come into it? There must be some valid reason you must be explaining.
Under Companies Act, it is within the competence of the government to regulate, and we can provide it. That's why we are bringing by way of this bill. With this request, I request the August out, it may be kindly be passed.
Yes, yes.